Dr. Singhvi completes.
Then you see
There are some issues which
All right.
I as a governor cannot deal with, my friend will deal with.
That would be a sur rejoinder. Let him say it now. I'm not opposing his saying. Your Lordship is permitted to say it.
No, no, after dealing with your
he may be wanting
okay.
to reflect on it for a couple of minutes. That's all.
Some paras I'll point out at the end, which were
No, no, this will be a sur rejoinder. This is not.
whenever your lordship says. So
All
I
right.
can read it.
We'll see.
Unless your Lordship will allow a note. Otherwise, your Lordship will have a full-blown sur rejoinder in terms of 2
We
minutes.
thought allowing a note would be prejudicial to you. Therefore, we said we'll hear them in all.
He's agreeable, he's fair. Not
Sur
agreeable.
rejoinder. There will be a sur rejoinder.
All right. Mr. Paul, you circulate a short note.
Yes.
Not more than 2 pages. Yes.
Not more than 2 pages. Give a copy to.
That's
Very
May I take one suggestion, subject to what your lordship says. I'll take exactly 2 minutes by the clock and just give the paragraphs. Can I do that?
That can be in the note. That can be in the note.
Only 2 minutes. That is in para 119, my lords, of Bomai. Specifically, the issue of legislators withdrawing support is taken care of. Bomai was a case of 2 parties merging and then a few MLAs withdrawing support. In para 119,
Just
it
a
is-
second, we'll just make a note of it. Bomai,
para 119,
just one second.
PDF
Page.
368 of the compilation, volume 2.
Yes.
It is specifically said in para 119, in this connection, it is necessary to stress that in all cases where the support of the ministry claimed is to have been withdrawn by some legislatures, the proper course for the testing the strength of the ministry is holding the test on the floor of the House. The only argument that I'm seeking to make, my lords, that this is a flawed argument from the other side, as if there is an alternative mandatory mechanism provided. Under the Constitution, there is no alternative mandatory mechanism provided to say that this should have been done and not that. When a governor looks at a position where MLAs come forward and say we are withdrawing support, to say that till yesterday you were together, today you are not together is not after Rameshwar Prasad, the mandate of the governor at all, because that amounts to getting into the ethicality and the correctness of who should be with whom. Just testing the proposition, the BJP and the Shiv Sena were pre-poll alliance. Now someone could say post-poll, wasn't it unethical that for 30 years you were together and you ditched and went with someone else? I'm not getting, now that's not the governor's domain.
Okay.
All that the governor sees is,
That point you made now.
the governor sees is, do you have the majority or not, close it on the floor of the
Bomai you have cited. Then what else?
Secondly, my lords, para 191
Of?
Nabam Rebia.
Yes.
Read with para 233 to 235 of Nabam Rebia.
33.
233 to 235 of Nabam Rebia specifically deals with Article 179, subclause C and removal. It is absolutely incorrect to say that Nabam does not deal with removal at all. Para 191, 233 to 235 specifically deals with Article 179, subclause C and removal. Thirdly, my lords, para 238 of Nabam, because this whole argument of intention to remove, actual removal, Justice Mishra deals with it and says, you will not wait till the date when the resolution is moved. The moment an expression of interest is given, an expression of interest is bound to be by way of a notice. The moment that notice is given is when the clock starts ticking, because between the intention expressed to remove and the actual resolution being moved, you can actually alter the composition. So that's dealt with, my lords, there. Lastly, my lords, this whole, last just 2 arguments. Form 1, what I had mentioned, my lords, was when your lordships had asked me in that context, that is any post mentioned? There is no post mentioned there. So the purpose of what I wanted to say to your lordships, maybe I should have made myself clearer, is that under Rule 3, just show me Rule 3, that where designations are given, where it says a statement in writing containing the names of members of such legislature party together with other particulars regarding such members as in Form 1 and the names and designations of members of such party who have been authorized for communicating with the speaker is given by the leader of the legislature party. And if your lodges were to have Form 1, it is just have Form 1 for a minute. Page,
Is furnished by the leader of the legislative party.
yes. And then it says name of the corresponding political party. So and then lastly, my learned friend made an argument. Please come to that party in the beginning. Just quickly, that party. But let's please see how is it being read. Firstly, please have G, 2G for a minute. My lords have
Doctor.
2G.
Yes.
Member means a member of the Maharashtra Legislative Assembly. Then F says leader in relation to a legislature party means a member of the party chosen by it as its leader and includes any other member of the party authorized by the party to act in the absence of the leader as or discharge of the functions of the leader of the party for purposes of these rules. My learned friend wants your lodges to read this, devotes the rules and say it means political party. And now please have Rule 3 for a minute. Subclause 5, just have rule.
Leader refers to the person who is designated by the party.
By the legislature. A member can only be the leader of the legislature party. That's what I read. No one else other than a member of the
No, but see
legislature.
the definition of leader. It's very clear. It is designated by it. It means by the legislative.
Yes.
The political party.
Political party.
No, it doesn't use the word political. That is your
No,
interpretation.
no, but this
No,
is very clear. This is
Yes.
very clear. Just read the rule.
Please read
Yes,
that.
the rule
Read the
is
definition.
In
definition.
relation to a legislative party means a member of the party chosen
Yes.
by it as its
Yes.
leader.
by the party, according to us here, means that it's the MLAs who get together and elect.
No, no,
leader.
no.
My lord,
This is a party means chosen by
My lord,
it
please
means
see.
by the political
No, my
party.
lords, please see what 2G says.
And the word which says and includes, that makes it even more clear.
My lords, may I?
And includes, just read and includes.
Yes,
And including.
I'll just read that. For a minute, just have 2G for a minute.
Give a note.
Just a minute, just have 2G for a minute. 2G, member means a member of the legislative assembly. Member means a member of the legislative assembly.
Right, has to be.
Then leader in relation to legislature party means a member of the party chosen by it as its leader. Manoj, it's the elected legislatures who choose a leader of the legislature party. My learned friend is trying to say that somewhere else.
But leader, definition of leader.
Leader, Manoj, there is no, I don't think there's yes, leader in relation to a legislature party means a member of the party chosen by as its leader and includes any other member. Any other member is a member of the legislature party of the party authorized by the party to act in the absence of the leader. Now, just for a minute for the completeness, just have Rule 3, subclause 5 for a minute. Just for a minute, my lords.
Definition of leader is 2F.
I read that. I read that.
3-5. Okay.
Yeah.
3-5, where a member belonging to a political party, any political party, votes or abstains from voting in the assembly, contrary to any direction issued by such political party or by any person or authority authorized by it in this behalf, without obtaining in either case the prior permission of such political party, person or authority, the leader of the legislature party concerned, or where such member is the leader or as the case may be the sole member of such legislature party, such member shall, as soon as may be thereafter, and in any case within 30 days from the date of such voting or abstentions, inform the speaker as in Form 2 whether such voting abstention has or has not been condoned by such political party, person or authority. Malad's leader is always by the elected members of the legislature party. When is a leader is always, for instance, the MPs get together, the MLAs get together to appoint the leader.
We'll consider that.
Anyway,
As was done in 2019, and then what is important for your lodges to know is
So according to the party means the legislature. Party.
yes, and why I'm saying so is, my lords, everyone understood it to mean so because that was the party convention right through. That was a question, my lord, the Chief Justice put in the initial rounds of arguments that there has been a convention because those letters were shown. They've also understood it to mean the same thing. This is now an argument being made to somehow get out of it. That's all that I wanted to say, my lord.
The leader conventionally in every party is elected by the elected members of the legislature, whether in parliament or not imposed by the party. Party means the political party. That's the only interpretation which is in tune with the democratic principles. That you have the electorate voters, they elect MLAs, MLAs elect their leader, and the leader is responsible to the house and consequently to the voters. Because constitution does not talk of political party at all.
I hope they leave something for the written note, Willis.
My lord, lastly, I'll just end by saying my learned friend had also argued that the letter contained no reasons for removal of the speaker. When my lord Justice Kohli put to them that where is that letter, read that out. Now, my lords, one thing which has to be kept in mind is we are not dealing with a notice under disciplinary proceeding where someone should be given details of what is the case that he has to meet. The words used are for removal of someone. You categorically in detailed para says you lost the majority of the house. That's what Nabam said, that if you have confidence of winning the confidence, go and face it.
All.
Win the confidence.
All right. Yes, Dr.
Yes, my lord. That's all that I wanted to say. I'm very grateful, my lord, for this indulgence given by you.
Now, Willis, some of it my learned friend will answer, Willis. At the end, that will take us 10-15 minutes. He'll cover that. But let me, Willis, come to my first. Let me stick to my sequence. Just an aside, Willis. All that was done in the last 10 minutes was reference to everything but the whip. The only issue relevant is whip. Your lordship would be asked to turn parliamentary and party-based democracy on its head if you were told that whip is not issued by the political party. What your lordship is shown just now is totally irrelevant and red herring because it is intimating to the speaker and the house that in this house, my leader is so-and-so. That is a communication between those in the house communicating with the speaker. Speaker has to know whom to communicate with. It is no communication of the party with its members. That's the whip. And that the party issues, the party decides. But that follows apart. We'll come to those rules. So this is completely irrelevant. It cannot be anybody's case that in the context of a whip, the party, the political party is to be ignored and the legislative party is to be looked at. Now, but leave that aside. Let me go in my own sequence first. I'll come to that. Well, as your lordships ended before lunch, Mr. Sibal finished with a flourish, about democracy. Let me just start with that. Well, according to my respectful son, I'll come 7, 8.
You follow the same note, Dr. Singh?
Now, on the note, I have an apology, little bit of a mix-up. The note, my note came to me in the morning. I corrected it and sent it back. Somehow it didn't go through. So they have filed by mistake the old note, which I had not corrected. Luckily, sitting here, I found it, and I corrected it. It has been, we've got hard sets, it's been emailed, but your lordship's uploading is in your lordship's domain. So, the court master was told all this. So, your lordship may have to either upload it or have the hard sets. Because there's a mix-up, the uncorrected note came here. I made many corrections in that. So, this is A7, lordship call it A7. And my learned friends have all got it, pre-lunch. This will be in substitution, I'm sorry. This will be in substitution of A6. A6 is the wrong one, the earlier one.
A6. Region the final PDF. ये रूम कर देना नया अपलोड कर देना.
Let me just summarize orally and then I'll come to the note because it will be much easier to follow the crux of my submissions. May I start? Your lordships have got one, either the hard copy or the soft one, whichever your lordship is using.
Same. Same. What is the change?
No, there are a lot of changes. Your lordship may just take this one.
Starting is the same paragraph.
No, starting, but there are changes. Lordship may chunk the other one, otherwise lordship will be confused with the other one.
So just comparing, but it...
No, there are changes. I lordship may just tell your lordship's assistants to delete that earlier A6. That's all. Otherwise, there may be some confusion. There are whole sections which are added, etc. That's all right. Your lordship will use this. Now, well, the first submission, and I'm not going to follow this sequence. Allow me to oralize. Well, my first of my 8 facets is something which is repeatedly fallen from your lordships, and well, yesterday it fell directly from my Lord Justice Narasimha. That well, your lordship is concerned about democracy, majority becoming less, or your lordship use the word overwhelming numbers going this way or that way. This connects with that. Sibal will answer in one way. I'm now giving your lordship a different facet. Because my submission is that your lordship has to go back to the origins of the 10th schedule. And first point under this head Balas, is that the 10th schedule has 2 components, not only one. One is a prohibitory negative code. It's a negative code. So a negative code is what you should not do. Violate, whip, voluntary resignation, cohabiting with other people, etc. But there is also an affirmative, positive part of that code. And what the 10th schedule does is to strike a balance between the negative and the positive by a constitutional amendment. It is my respectful submission, it is vital for your lordships to give effect to both negative and positive in letter and spirit. Because your lordship is actually implementing the constitution. And some of the arguments of the other side have bordered on suggesting that a mere, I'm using the word mere advisedly in comparison to a constitutional text, a mere symbols order will be competing with a constitutional text. That would be completely anathema to all known principles. What are these 2 codes, Balas? The negative code is that you, in a nutshell, I'm just saying, in a nutshell, I'm oversimplifying. You will not voluntarily give up membership to 1A and you will not violate whips to 1B. Just in a broad summary. What is the affirmative permissible activity? You are entitled to dissent only within that permissible zone. Otherwise, why enact the 10th schedule, Manas? Prior to 85, you didn't have the 10th schedule. You had Jungle Raj, which you called Ayaram Gayaram sometimes, but then you can also justify that in the name of free speech, free action. What you did here was you allowed a zone of activity, permissible, affirmative, but you cannot say that I will go beyond that permissible and thereby violate indirectly the negative code also. What is that permissible activity? The affirmative code of conduct. One is a faction or a split till the 91st Amendment. They gave you an escape route, advisedly, consciously. That has gone. It was there. So, the Constitution famous thought that along with a negative code of conduct, so as not to stifle you completely, we give you an escape route, exit route of faction or 1/3 or whatever it was called. Second, merger. Third, and this is actually the most important part of 10th schedule. Elections, barring a few cases, in the days of 1960s, etc., there used to be a very strong, large number of independents. Independents have now dwindled. The statistics show. Even then, in terms of 545 Lok Sabha, you had hardly 30, 40. But independents commanded a coordination. My father also got into Lok Sabha on an independent party-less ticket. So I know at that time it was Mr. Nath Pai, so many people. But today, even then, party democracy was, everything was based on party. You got a ticket and you fought and you won because the party projected you as its candidate. That is now, much, much truer after the 60s, 70s onwards. Today, the number of independents compared to the 60s would be a fraction. So it's party-based democracy. You like it or not, it's not for anybody to question. We've chosen it, but there's nothing perfect. Some people say US is better, some people say European, but this is what we've chosen. And now, this third Third balance.
Third point is what? What is the
So
point?
one is,
Okay.
balance,
Split is permissible, merger
second
is
is merger.
permissible.
Third now.
What's the third point?
Third comes with the light of what I said just now. The whole idea of the 10th schedule is resign and recontest. That's what is stopping you from doing. You enter the door through this door, and then you retain your ministership and seat while exiting through the other door. Sorry, not permissible. Resign, have the courage of your now, you are a very vocal freedom speaker. You have the courage of your conviction.
Which Justice Jeevan Reddy referred to in that extract.
I'll be dealing with some of
It
that.
was not in the context of the 10th schedule.
But I'll be dealing with that. Some judgments have referred to it. I'm going to suggest that because this is the core question my Lord Narasimha asked, my Lords asked earlier. What do we do when an overwhelming set of people want to express dissent? 9/10, let's say 9 out of 10. Let's take an extreme example. How do we balance and countervail these two competing balances? The 10th schedule says you can go thus far in balancing, not further. Whereas if you are so much for free speech, courage of your convictions, this is a rotten party, I can't say, resign and contest. Recontest, what is the problem? Then the fourth is the exemptions. Apart from merger, there's the exemption clause, condonation, whatever. All that is given there. Now, what we have to see is that if a constitutional amendment balances the prohibitory with the affirmative part, you cannot find an excuse to circumvent the prohibitory part by going beyond the 4 avenues of the affirmative part, now only 3. Action is gone. Now, let us take this further, because that's your Lordship's query. I'm sorry, there is a fifth one. I forgot. There's a fifth one. I'm now breaking it up. There is a fifth balancing on the affirmative side. You are so concerned about free speech. You are resigning is one, or you absolutely hate where you are. You go to the Election Commission and start your para 15 proceeding that I am the real party. But you do that without indulging into the prohibitory part. That's keeping the sanctity of the 10th schedule. Now I'm addressing the core dilemma of my lords. Let me develop it in a minute. That's also a statutory remedy, lower than constitutional. So the fifth is, now actually only 4, because that faction is gone, split is gone. So 4. The fourth would be file a complaint to the Election Commission, say, look, 9 of us are standing here, we are the party, recognize us. Till then, don't do any prohibitory activity. The Election Commission will or will not recognize you and is subject to challenge. What does this do, This maintains the sanctity of the 10th schedule and maintains the negative and the affirmative parts of the 10th schedule. What does my lord normally prefer? A option I give your lordships, which reduces the other option to vanishing point? Or an option which harmonizes both? Elementary principles tell your lordship by 1,000 cases that your lordship prefers the harmonization approach. Elementary common sense shows that my learned friend stand reduces the 10th schedule to vanishing point. It is as good as a dead letter or a repeal. Which is better? The answer is self-evident. Now, here, just see, how this dead letter vanishing point arises. You don't resign with the courage of your convictions to fight another election. You don't go to the Election Commission till much later. Almost a month, just under a month. After 21st, you went to Guwahati. 19th, you go to the Election Commission. 2 days before a month is ending. You don't seek condonation. What you do is, what I call a 3-steps novel procedure to annihilate the 10th schedule. It's a 3-step novel procedure. Step 1 of which is disable the speaker by giving him a mere notice. So the man can't touch you on the 10th schedule. Just see my submission of harmonization versus vanishing point. Step 2 of this sinister 3-step novel procedure is to forward resolutions parallelly to the governor, who in turn makes it the basis of a trust vote direction. And the final step 3 is the act of being sworn in as Chief Minister.
Sorry?
The act of being sworn in as Chief Minister. With another party fully supporting, in whose lap you were in Guwahati. Now, I'm not on the, just kindly consider. You don't follow the affirmative part, which gives you play in the joints and leeway, flexibility. You don't resign. You don't merge. The most important, interesting point is you don't merge. Just see for a minute that B, 4B. If you are sitting in their lap and they are supporting you, and the last minute, instead of them becoming Chief Minister, they make you Chief Minister, what is the problem with merging? So, you say to hell with the 10th schedule, it gives me an escape route, I'll ignore it. I'll go to the 3 steps. And the language, without opening it, where his original political party merges with another political party, and he claims and any other members of the original political party have become members of such political party, or as the case may be, of a new political party formed by such merger. This is directly snooking a nose at the 10th schedule, which is a constitutional creation. It is, I'm sorry to use colloquial language, it's actually saying, look, to hell with the 10th schedule, we have made this 3-step procedure. Why on earth could you not recontest, resign, merge, or the 4th one? Condonation, I'm not getting into, that's another one. Go to the Election Commission and file a complaint then. On 21st, instead of Surat and Guwahati, why did you not file the Election Commission? So this is the first answer. This is one of the best answer at least I can give to the direct question, but there is a consequential answer further ahead. I'm putting it against myself and trying to answer, because I put this question to myself and Lordship asked it yesterday. Now, a possible argument will be twofold. That is no argument, because how it works in actual law, a fact is not an argument against me. If the law is a prohibitive and a affirmative, then you jolly well follow it. That's the object of creating a constitution. But now I'm giving an answer against me, even though it doesn't arise in law. The answer is, what happens, Mr. Singhvi, if between me, that is they, applying to the EC and doing these things which Mr. Singhvi is advising them to do, the speaker disqualifies you. I'm putting it bluntly against myself. The first answer is, so what? Why was the 10th schedule created? Is the speaker doing something unknown to law? But there's a better answer. If he disqualifies you, there is full judicial, this is on the basis wrongly. There is full judicial review. No, but you can't, your lordships can't find a solution to everything which the Constituent Assembly, the Constituent amending people did not make. What is this answer? That what do? I will be disqualified. Well, jolly well you'll be disqualified because the 1985 framers gave this power to the speaker. Is the possibility of an abuse ever the test of the power or its existence? Can it be? Otherwise, how will your lordship decide anything? Yes, that phrase comes from Rajnarayan versus Indira Gandhi. Possibility of abuse is not the test of power. Give that citation.
Hindustan judgment. Hindustan construction, some judgment is there.
Also Hindustan construction.
Abuse of power cannot be the...
Your lordship should judge everything. Oh, what will happen? What may happen? That's not the question. Here, and your lordship is talking of lesser cases. Here, the constitution was amended to give this power. And the apprehension is, I will not go on 21st to speaker, to EC. I will go to Guwahati because I'm scared of a disqualification. Now, let us look at the second. I'm giving a lot of extreme examples against myself. You have a full review possible. My review is much more truncated. It takes 1 year for me to get this hearing before your lordships. Your review is immediate on a wrongful decision against the speaker. And your lordship knows Kyoto says, after a final decision of the speaker, you will get a stay of that. You can't get a stay while he's deciding. You can get it afterwards. Of the disqualification also. Only a quia tibet is stopped.
You are comparing that with what?
With the fact that if you don't do this and stay and make the 10th schedule a dead letter and install a new government on the basis of ignoring the 10th schedule, that is much less reversible by sheer passage of a few days than your right to challenge. Today, what is the whole argument? It's a scrambled dead, it's a fake accompli. Your lordships can't reverse it. It's 1 year down the line. That's the real argument today. That's the argument we are facing. Now let me give your lordship another bizarre example against myself. These are not normal examples, because I don't know of except a very few number of cases where you have the courage of conviction to resign and recontest. That resignation is impeded. It happens. There are 2 or 3 judgments we have. But normally, let me assume against myself that I resign because of my high standards and my resignation is not accepted by the speaker. That's the worst I can assume against myself,
Right.
I can't assume something more than that, Again, the speaker can only reject my resignation and disqualify me. He cannot do anything more. The speaker cannot say that you shall do this or that. He'll at the most say, I reject your resignation and I disqualify you. Same remedy. That remedy, your lordship will stay in 2 seconds. Suppose your lordship had an MLA who resigned to fight a new election and the speaker, there may be bizarre cases, I don't know. Speaker said, no, I disqualify you. How long will it take a court to give a stay of that order, I mean, your lordship is dealing with these cases on and off every day, in some form or the other. But here, none of these 4 or 5 possibilities is allowed to be tried because you adopt a 3-step procedure to annihilate the 10th schedule. Which brings us to the harmonization principle. I'm not going to cite law about harmonization. From ordinary petty contracts to constitutional law, your lordship's first principle is harmonization. From statutory, delegated legislation up to the constitution. Whereas I want to make the different point here that why did the 10th schedule come? We'll read Mr. Ashok Sen's speech in when he piloted this 85 thing. The whole purpose is that you have come through a party seat, you go and face the electorate again, whether with that party, independent or a third party. That's the whole long and short of this. Have your lordship ever heard this happening except in some very rare cases in England or other democracies? There's no concept, I've come on a party, I'll either resign or I'll just leave that and fight again from another party. That was the whole purpose of this. But what you are telling the court is that no, I will affirmatively not resign. I will not go to the EC. Why? Because I'm scared that somebody will disqualify me. But then what was Mr. Ashok Sen enacting in 1985? He's enacting a power of disqualification for changing a party. What is the purpose of 2/3 of the parliament saying so if you can simply...
What is the harmonization principle that you're referring to?
Harmonization is this 4-fold, 5 originally with defection, otherwise 4, are the flexibility, play in the joints, affirmative permissibility part of the 10th schedule. And the 2(1)(a), 2(1)(b) is the negative prohibitory part. You can do all these 4 without doing the negative part. For the negative, you don't have to violate the negative part for any of these 4. I will say even if you go to the election commission, you don't have to violate a whip. You don't have to voluntarily give up your party. You say, I'm on principle, please decide this.
So in other words, you are saying other than those 5 instances,
4 now.
Everything else falls within the net of 10th schedule.
And one more thing I'm saying. That 10th schedule, absolutely correct. And the 10th schedule has both parts. It has those 4, it has a negative. It creates a whole code by itself. Harmonization means that your lordship will adopt my submission and interpretation because it harmonizes the negative and the positive. Now for 30 seconds, see if your lordship does not adopt the harmonization principle. The only thing a lordship will have to validate is the 3-step procedure. There's nothing else. It's staring a lordship in the face. The 3-step procedure, I want to ask myself, in which case will the 10th schedule bite? Let's be very blunt. What your lordship will do is your lordship's domain. But today, your lordship's other option, other than my option, which I am submitting most humbly and respectfully, is adopt the three-step procedure or validate it or recognize it. But then how will 10th schedule apply? It cannot. And then, Malas, your lordships would be actually adopting an interpretation which reduces the 10th schedule to vanishing point. Actually vanishes, then vanishing point, it vanishes. Every case of defection, I will say, I'll not resign. I won't go to the EC. I won't merge. Merger is given to you by the para 4 of the 10th schedule. I will not do it. But as your lordships was told, I am the party, I am the overwhelming majority, I am the main person, I am it. I am it. Therefore, to hell with the 10th schedule. So on principles of interpretation and much more so of constitutional interpretation than even statutory. This is a much better way to look at it than the contrary view. Because your lordship gives meaning to both sides and your lordship does not adopt something. What is this other adoption which is propounded to your lordships? On the high moral principle of democracy, dissent, free speech. Each of my 4 options gives you that option. So what the 10th schedule does is, it says, I am giving you a free speech option. I am giving you a democracy option, but within my own terms. I'm not giving you a jungle raj free speech and democracy option. Otherwise, why would I enact a 10th schedule?
See, but merger, Dr. Singhvi, was not an option open to them because they were not claiming to merge their party with either the BJP or any other party.
With respect, I'm sorry to interrupt. Why not?
So, merger was not an option.
No, it was an option. They did not choose to exercise it.
You're right, you're right.
That's correct.
It's an option.
They chose not to exercise an option.
In the abstract, but they were not following the merger route at all because it's not their case that, look, this part of the Sena
That's exactly my point.
With another party. That is not
That's
here.
exactly my point with greatest
Then
humility.
the only point is that in a situation like this, where they say that we have lost faith with the leader of the party,
Yes.
then the only option according to them, according to you, is that you resign and recontest.
No, I will stick to my 4 options.
That's
I'll say all the 4 options are.
No. What do they do then?
No. Whereas resign is one.
Right.
These 9 people will merge with another political party. Why not? But the fact that I don't exercise an option
that is not an option because merger means that their political identity as the Shiv Sena is lost then.
Well, then in that case, if the 10th schedule says that I recognize only this path of exit from this room, you can't say I'll make a new tunnel to get out.
But you know, Dr.
He can't make
part of your argument is a problematic argument. I'll tell you why. Because your argument postulates that if you have a dissension, then the only way you can express the dissension is to leave the party and merge somewhere else. They say, sorry, we don't want to leave. I mean, ideologically, I am a Shiv Sena man. I don't want to leave, he says. He says, I don't want to leave the party.
So as per
kindly see the
even if somebody applies to the election commission at the initial stage instead of in the legislative assembly and says that we now want the political party to
that we are the political party, recognize us.
So even that, according to your argument, is impermissible then?
No, because
that's outside the
so long as
5 instances that you have given.
No. One of my 5 is EC.
He's not resigned.
No. One is resignation, one is split, which is gone now, one is merger. The 4th is EC. 4th is EC. Now, if I apply to EC without violating a whip and get a decision, if I apply to EC without voluntarily resigning, it's perfectly permissible. I can't be saying I'll topple first and then I'll apply to EC.
So remain a member, be a part of it, and
contemporaneously vindicate your principle. Absolutely. I just see the reverse of it, but just consider how it will apply. You first topple the government, then you go to the EC. And why did you write the 10th schedule?
That we understand.
No, and also, apropos my Lord Chief Justice query, are you harmonizing or not? There is one more thing. The fact that you don't choose consciously not to exercise an option does not mean you can wish away the option. The option is a constitutional option. It's a constitutional option. It's as equal to split as it was earlier. You don't exercise it, it really amounts to saying this, I want to avoid the 10th schedule. So I will put blinkers and close my eyes to 4 options available. 4 constitutional options, the 5th one is deleted. And I will choose a new option, which is only the 3-step procedure. First, disable the speaker. Second, approach the governor. Third, be sworn in.
See, the negative prohibition in the 10th schedule is twofold. One, voluntarily giving up a membership, and two, defying a whip, 21A, 21B. The 10th schedule certainly does not have any provision by virtue of which there is a prescription if you do not give voluntarily, if you do not give up the membership of the party, and yet exercise the right of working your remedies within the party.
Then you cannot be held to be a defector.
Right.
And that is the whole purpose. You were elected.
That's exactly the case, no?
No, but then in that case, why do you enact the 10th schedule? Because 10th schedule is not saying that Article 19(1)(a), just see 194, very interesting article. It is not saying let me put this harmonization, which is a very important principle, in another way. What is the scheme of this entire system? Well, if your lordship were to make a standard as broad as if you have a dissent, you can violate the 10th schedule, then your lordship is unmanageable.
But your argument, Dr. Singhvi, would be
Yes.
the extreme argument on this side, which possibly you can adopt also, is that any dissension amounts to the voluntary giving up of the membership of a
No,
party.
I'm going to give more. I'm not extreme. The other argument is extreme. I'm going to give a harmonized answer. Immediately to that, the principle can never be dissent. I'm not happy, therefore I can go. Three answers. One, everybody has dissent. Which political party? There are enough inbuilt outlets within the party to express dissent. One. That is what your lordship will always say. Two, the dissent within the party at the appropriate fora can be followed by any of these four. Three, you, if you are having dissensions and you are not satisfied with the party system, then you will simply express it that I am resigning or going away with 9/10 of the people. But how will you say that mere disagreement entitles me to topple? Here they have not expressed dissent. It's not a case of dissent. I have not gone out and spoken against the party. Dissent plus, this is dissent plus. Dissent plus toppling. Your lordship remembers I started, I think during the Navam Revia hearing. Your lordship notices 191(2) and 194. Your lordship may not remember that, but just kindly turn to that for a minute. 191(2) is a clear statutory, constitutional prohibition in the 10th schedule saying you shall be disqualified. That's the 10th schedule comes from 191(2). Now, 194, which follows 2 clauses later, says, subject to the provisions of this constitution, there shall be freedom of speech in the legislature. And 19(1)(a) is even more reasonable restrictions. Now, it can't be that mere saying free speech, I can violate, I'll violate, you can act within the party constitution. Whatever the party constitution allows. Some party constitutions have, even appellate bodies, some have two-level things. You can actually do all of it. Before you go by these 4 escape routes of merger, resignation, you can do all of it. But ultimately, if it doesn't work, you have to take these 4 routes. And 194(1) makes it clear, subject to the provision of this constitution and to the rules and standing orders regulating the procedure, there shall be freedom of speech in the legislature of every state. This is not an open-ended charter. And plus, kindly see the consequence.
Dr. Singh, according to you, when does the governor then order a trust vote?
No, the governor has no role at all in such a situation. Governor, first answer to your lordship is when the government is formed, or when the government is about to be formed. That's the inception argument. The governor will never come into a 10th schedule situation. It's what is your lordship considering? An intra-party dispute. At the end of the day, what is this dissension? I don't like you. I don't agree with you. Intra-party. How does it come to intra-party dispute? How does it even recognize it? There are all kinds of feuds going inside parties. How does my lord lay down in English language a judicially manageable standard to control the governor peeking into intra-party disputes? It will be the thin end of the wedge. This is nothing but political party A intra. The governor will deal with some constitutional issue or something relating beyond intra-party. And how will the governor deal without any specific article, mind you? In a sense, superseding and overdoing the 10th schedule, which is a constitutional article, with 191(2), which we tend to forget. 191(2) read with the 10th schedule.
ऐसे कितने बच्चे हैं जो घर पे बोलने में तो बिल्कुल नहीं शर्माते,
Picking out a person and saying,
picking out a person, because
correct?
even assuming that the governor had material to call for a trust vote, what is the basis for picking up Shinde? Second, that the governor had no material to ask for a trust vote. That there was no valid material at all
That's a
on the
core
basis of
question.
those three circumstances.
That's a core question. And that goes to the heart of the matter. If I may digress for 30 seconds, Mr. Tushar Mehta was right when he quoted the couplet, but perhaps didn't realize that the second sentence applies against him. He quoted Bashir Bhadra to say, "Chup rahe to galat fehmiyon और गलत फहमियां और भी बढ़ी, उसने वो भी सुना जो मैंने कहा नहीं, उसने वो भी सुना जो मैंने कहा नहीं." Whereas the governor in his letter at 326 PDF talks of a resolution to exit the government, which doesn't exist at page 55 of the resolution itself there. So he's hearing things jo kaha
The
nahi.
resolution doesn't say that we are exiting the government.
Yes. So he heard something.
We had
said.
wanted to.
Well, I found a more appropriate one for Mr. Mehta. I found a more appropriate phrase for Mr. Mehta. Not Bashir.
So really, question was whether there was a valid exercise of power by the governor to call for a trust vote. And but what happens if we come to the conclusion that there was no valid exercise of power by the governor to call a trust?
Everything false.
Everything false is very
No, I'll be dealing with Bomai. That's a core question. Your lordships is saved a lot of unnecessary exercise if your lordship comes to that conclusion plus follows Bomai, which in any case is
so
9
then
years.
you, according to you, what? We reinstate the Uddhav
Just
Thackeray
straight away, let me just change my tack and go to Bomai.
But you resign, no?
No, I covered in my note directly. 5 reasons. Justice Shah asked me that one in the beginning, your lordship asked me that. I'll straight away answer. That is actually a red herring.